studio 972-235-5555. So get ready to ask your question related to immigration and naturalization or anything related to family law, corporate or civil matters. Once again, the number in the studio 972-235-5555. Yes, you can call right away to get your answers right away. Would love to call on Pallavi Aluwalia on the airwaves of Anisha Radio 104.9 FM. A very good morning to you, Pallavi. So nice to see you again.
Thank you, Meetu. Glad to be here this Wednesday morning, and with your business matters, we're glad to interact with the community and to be able to answer some questions on the air. And I know we have callers that have been calling in, let's, without wasting much of the caller's time, start taking questions on the air.
Let's do that. And before I go to the first caller, do want to mention, Pallavi, that we got a call early on my show, and that lady wanted me to convey to you that you do an awesome job.
Oh, how sweet.
I thought I'll let you know.
That is very sweet. Thank you, and I'll take the compliment, and I hope she's listening. And I know that you said it was someone who listens to us from Maryland.
Yes, her name is Raksha.
Okay, how sweet. Thank you, Raksha. So let's go ahead and we'll start taking the first call. And if there are any updates that I have, then I will bring them on the air.
Let's do that. Going to our first caller, Anisha Radio. You are live on the air. Go ahead and ask your question, please.
Hi, Pallavi. My name is Shubhra, and my employer is actually filing a green card for me. I'm on L1B visa, so I'm getting into an EB2 category.
Okay.
So wanted to see if I do not get my GC before my 5 years expire, will I be able to extend my L1B considering it's a pending application?
No, that rule does not apply to the L1B scenario. It applies only to the H1B. For you to avail of the green card pending and the AC21 portability and extensions based on the filed labor certification or an approved I-140, you have to be an H1B. So the right mode for you would be to go from the L1B to an H1B, have that green card application going on in the background, and once you have that I-140 approved, you'll start getting three more years on H1B. Of course, you have to first take on that H1B for a year first.
All right. Thank you so much, Pallavi.
All the best, Shubhra.
Thank you so much for your call. 972-235-5555, number in the studio. Anisha Radio, you're live on the air. Go ahead and ask your question, please.
Hello?
Yes, we can hear you. Go ahead and ask your question.
Okay. I have a question. Because I have a friend of mine, his son wants to come here. He has a 5 years multiple visa. Let's say if he comes on here for 5 years multiple visa, can he convert that visa into the F1 like a student visa?
Well, so the plan should not be to do that, because intent is very important in immigration law. And if you're coming here as a visitor, then your intent when you enter should be that of a visitor, not a preconceived intent to get onto another status, because then the law requires you to actually come and enter on that status that you want to move to. With that having been said, if somebody were to file an application after 2 or 3 months, you can get past the intent issues for a change of status. Of course, there should not be any contact with any school or seeking any I-20s or doing any pre-qualifying things for those 2 to 3 months from that time of entry, because those would count against your intent. Okay, so at the time of the request for evidence, USCIS is known to ask individuals to submit the emails and the contact that they made with the school, and that's part of the request for evidence, and they're trying to understand when did this person actually have the intent to become a student, and if it was within a few months of the entry, then they obviously violated the conditions under which they were granted entry. So that has to be something that you have to take care of. But the answer to the simple question, yes, people do come here and they can convert to students, but that should not be the way that they plan it.
Oh, okay. Thank you very much.
All the best.
Thank you so much for your call. Moving on. Anisha Radio, you're live on the air. Go ahead and ask your question. Phanisha Radio, you're live on the air. Go ahead and ask your question, please.
Oh, yes, I'm from Dallas. My name is Pankaj. I'm illegal, so is there any way we can make a status?
Yeah, at this time, I think we're all awaiting immigration reform. The executive action did seek to give some benefits to people that were either children that had come in here and it had extended some deadlines, or people that had had kids here. But the executive action got challenged and is right now in the Court of Appeals, and it's going to go up all the way to Supreme Court. So this time there are no options, but I'm sure that immigration is, though a polarizing issue, it is still a concern to a lot of people, because there are a lot of undocumented people like yourself. The counts are up to about 11 million or even over that. So hopefully there should be other people that are thinking, the legislators that are thinking to make these reforms that would give you options. But for right now, the answer is no.
I cannot apply on H1.
Yeah, when
I'm
somebody...
qualified, my daughter is born here and paying tax from every year.
Yes, so the H1B is a work visa, and depending on how long you've been out of status is how you can use it. If your being out of status is under 180 days, you still have an option to do consular processing on your H1B, and that too when the quota is open and you can apply. If that's not the case, then no, the H1 would not be an option because the consulate will not allow you to enter.
Okay.
All right.
Thank you for your question and all the very best to you. Moving on. Phanisha Radio, you're live on the air. Go ahead and ask your question, please. Phanisha Radio, you're live on the air. Go ahead and ask your question. I guess we lost that call. Please call us back. 972-235-5555. Number in the studio. Going to our next caller. Phanisha Radio, you're live on the air. Go ahead and ask your question.
Hi, I have a quick question. I applied for my mom's green card for immigration, and she's in India right now. She has her interview scheduled for November, first week of November.
Okay.
So I've heard that we have a 6 month period until then she has to travel here within that visa time frame. Is there a way to extend that 6 month period without rescheduling the interview date?
No, I mean, the point is that from the time that you get the green card, you have to show that you're a resident and you intend to be a resident. Staying away for a long time from here and outside of the validity period would end up in the intention not being there. So to immigration law, there is a lot of intent that the government interprets from your actions, right? So if the action is non-entry after the immigrant visa has been given to her on her passport, then they assume the intent to not be a resident. So that would be an issue. Getting an extension, I don't think that would help or even be possible.
Okay, so it's just advisable to come within that time frame without asking for extension or even considering that option.
Right.
Okay, thank you so much.
Thank you for your call. Going to our next caller, Phanisha Radio, you're live on the air. Go ahead and ask your question.
Okay, thank you so much.
You need to turn off your radio before you call. Once again, Phanisha Radio, you are live on the air. Go ahead and ask your question, please.
Hello.
Yes, go ahead and ask your question.
Okay, my question is, let's say I'm here with the employer and I'm on H1 and I have I-140 approved. Now if I want to change the employer, can I do based on I-140 or they need to start another GC process from scratch?
Yeah, so they will have to start that green card process if you want to get your 485 file with this employer. So for you to be AC21 portable in the sense that your I-140 is completely portable, you have to have the I-140 approved, number one, and number two, the 485 pending for over 6 months. If that's not the case and you don't have your 485 file right now, for you to be eligible to file for your 485, you do need an employer's offer. And if the second employer B is where you move, they will not be able to authenticate that job offer until they have also done the PERM and gotten the I-140 approved.
Oh, okay. So basically, yeah, my 485 is not done. because priority date is not current. So basically, it's just like they can just put the date, hold the priority date, but they need to do everything from scratch, right?
Exactly. So they will get the priority date of your original PERM filing at the time that they get the I-140 approved. They have to get that in at that point. But if you have to move to employer B, then you'll have to take and do the entire process and recapture that priority date.
Okay. All right. Thank you.
All the best.
Thank you so much for the listeners who are tuning in just now. This is Your Business Matters with Pallavi Ahluwalia from Ahluwalia Law Offices. To get in touch with her beyond the show, you need to call her front desk manager at 972-361-0606, ahluwalialaw.com, their website, or you can also log on to yourdesilawyer.com. And the number in the studio to get your answers right away, it is 972-235-5555. Going to our next caller, Fun Asia Radio, you are live on the air. Go ahead and ask your question, please.
Hi, my question is, I am a green card, I'm a U.S. citizen. My mom who's in India, what's the process, how much time and money does it take to apply for a green card for my mother? I know there's one way where she can be in India and I can start the processing, and the other one is if she comes in the visitor visa. Can you explain what the difference in both options would be in terms of time and money?
Yeah, so the process currently, when somebody comes in here on a visitor visa and then file for an adjustment, the first problem I always talk about this is intent. There should never be an intent to come in here on a visitor visa and immigrate. That's not allowed. Okay, however, if somebody comes in and they want to stay back and they do end up having an option, like for your, the example would be a case like your mom's where she has her daughter applying for her, then the I-130 and 485 will be filed concurrently. It takes roughly about 13 to 14 months currently. The filing fees alone are, I'd like to say about $1,570 or so, and these are $1,590 actually, and these are filing fees that make up the I-130 and the 485. If you go through lawyers, of course, there are fees on top of that. Now for the consular processing, it's moving a bit faster. It's at about under a year right now. It requires you to file the first step here in the country, which is the I-130, and then to do the NVC packet, and that gets done in about 4 or 5 months. There's some NVC is picky about the kind of documents that they're looking for in terms of the originality of the documents. But the process in terms of filing fees, the processing fees are roughly about $700. So it's half of that, and the time right now is a little under the time, and of course on top of the 700, if you were to go through an attorney, then that would be the additional cost. So the timelines and the prices are here. The option here does allow the person after 3 months to get an EAD as well as an AP, which means a travel document as well as a work document, and that comes to you after about 3 months of filing the 485. So roughly from the time of entry, maybe a person should not and cannot file for about 2 to 3 months, and then you're looking at an EAD AP 3 months after that. So after somebody enters, within about 6 months, they'd get the EAD AP. So there is a length of time in which they can't either travel or work or do anything like that.
I see. And one more thing, for the documents, it's my birth certificate as well as her birth certificate?
Correct. They're both important.
Okay. Is there anything else in terms of attached documents?
Yeah, I mean, you have to prove the relationship, you have to have pictures attached, you have to have the G325s done, and those go over biographic information of both you and your mother in separate forms. So if you're planning on doing it yourself, just read up on all the instructions that follow the I-130 and a bit
Much all the very best to you. Moving on to our next caller, Fun Asia Radio. You are live on the air. Go ahead and ask your question, please.
Thank you.
Fun Asia Radio. You are live on the air. Go ahead and ask your question.
Hi there. I'm currently working with employee, and my 140 is completed or approved, and I have a priority date. And I'm planning to move to employer B. And like to know, I completed my 6 years. I'd like to know if my employer B can file an extension based off employer A's I-140 if it is still valid.
Yes, your employer can definitely, the position of the government is, even if it is revoked actually or withdrawn, that you do have the option to use it for an extension. Now that is an option, or that is an opinion that has not been tried and tested. So I would definitely change the employer using the I-140 that is not yet withdrawn. And the employer B would get the 3 years benefit, or you to work for that employer in 3 years. After that time, if that I-140 is withdrawn, your H-1B still remains valid. However, in those 3 years, you'll have to make sure that you have your PERM approved with employer B as well as the I-140 and recapture the priority date.
Sure. One question I had is, if can I go back to employer A and work if the I-140 or my priority date becomes current for EAD?
Yeah, so it depends on the intent and whether, so the intent should not be, the intent definitely cannot be that you are doing that for the sake of the green card, and it should be more to the point that you have the intention to go work for that employer A at the time that you return to that employer.
Sure, definitely. Thank you very much.
Thank you for your call. 972-235-5555 number in the studio. This is Pallavi Aluwalia from Aluwalia Law Offices, giving you all your legal, answering all your legal questions live on air on Fun Asia Radio 104.9 FM. To get in touch with her for private consultation, do call their front desk manager at 972-361-0606. Going to our next caller, Fun Asia Radio, you are live on the air. Go ahead and ask your question. Fun Asia Radio, you're live on the air. Go ahead and ask your question, please.
Hi, this is Sudan. I have one I-140 approved, and I have RFE on I-485. My job title is medical technologist. I work in a specific department, and they asked me a visa screen certificate on that.
Okay.
And I applied for visa screen certificate.
Okay.
And CGFNS told me that I don't need a visa screen certificate. And USCIS confirmed with ILA in 2008 that people like me don't need a visa screen certificate.
Okay.
So we replied with all the ILA and USCIS meeting notes and the letter from CGFNS.
Okay.
So do you think USCIS will honor the agreement between them?
Yeah, so whenever there are memos that are published by the government, sometimes they are not regarded as law. And I can understand the visas screen, and you said you are a worker in the healthcare, but you're not actually a nurse or a health professional, correct? Is that what I heard?
No, I'm a medical technologist specialist, and I graduated from here.
Right, okay. And so they, obviously when you have a graduation that has happened from here and you have a degree here, so is your attorney contesting the requirement? Because if this is clearly an error that's being made by USCIS in their request, then besides the memos that have been published and the fact that there is a degree that has been accomplished here as opposed to being abroad, then that may be the exception to the visa screening.
In 2003, the case like mine was denied, and in 2008, the ILA confirmed with USCIS that if CGFNS thinks that visa screen is not required for this type of candidate, will you accept this? And USCIS confirmed that if CGFNS said, then they'll honor their decision. And there was another meeting on 2008, and Texas Service Center said that, okay, if you get a letter from CGFNS stating that you don't need a visa screen, we are okay with that. I'm a little scared, will they honor that,
Yeah, well, if it's being argued in that way, that there have been their own frequently asked questions that have been answered differently, it could be. Now, what is it that's being certified, and it is your your education, your experience and training. And what I don't have the ability to see is that how that case was argued to see which part of it did require the visa screen opinion. Because if the credentials from the past or the experience of the past were not an issue to the case and it completely relied on the US degree, then the visa screening is logically not needed, right? Now, I don't know in the arguments that were made in your case whether there was past experience and credentials that were needed, and that's the reason that the government is asking for it. So now, of course, the attorney definitely that you have should argue the FAQs, but the FAQs are, more treated as they're not the law, they're not the code, so they don't have to adhere to them. They're not even cases that can be quoted. They're just stances that the government has at different times, and their stance may change yet again. So you cannot rely on that completely, but it should be used.
Okay. And my friend, my company applied for 2 of us, and my friend was in the same boat, and his 485 is approved, and they didn't even ask for that.
Okay, all right, yeah, this is random. I see that quite often, or with the government, the same kind of case goes through, and then they may take exception to another case and may interpret it. Now, again, what I would pay attention to would be the kind of credentials that were argued at the time that case was applied, because if the credentials were foreign credentials, then the visa screening would be something that they can ask for.
Okay.
All right, all the best.
All right, thank you, ma'am.
Right, thank you so much. We have exactly 2 minutes left, Pallavi. I think that's all the time we have for today. But sometimes some simple things can get so complicated, right?
Yes, and no two cases are the same, and no two adjudications are the same, unfortunately. We have a lot of times with the same set of facts, one case just sails through, another one gets a crazy kind of an audit, and the facts of the case are very similar. But there are different officers that are looking at a different set of factors or paying attention or focusing on different factors. So the approval of one case does not lend credence to the fact that another case exactly like that will go through. And that's the way the government works on this one. But thank you so much, Meetu, for hosting me so well. And I see 5 or 6 calls still on the air, and I feel bad that we haven't been able to answer them. If the callers do call us back tomorrow, I think I should be able to patch into you and to be able to answer questions. So, and we may be able to do that maybe at 11 o'clock tomorrow morning. So if you were to call back, then I can try and answer the rest of the questions that I've left behind today.
That's great, Pallavi, and it's always a pleasure to have you on the airwaves of Fun Asia Radio.
Thank you, Meetu. You always do host me so well, so it's a pleasure that belongs to me too. Thank you.
Hear from you tomorrow.
Your weekly show, Your Business Matters with Attorney Pallavi Ahluwalia of Ahluwalia Law Offices. Call in with your questions at 972-235-5555. That's 972-235-5555. If you didn't get a chance to ask your questions, or if you prefer a personal or private consultation with an attorney regarding immigration and nationalization law, family law, business law, contract law, or civil litigation, she can be contacted at 972.
Discover the fascinating world of Yadra's handmade